When can a custody or support order be modified in Illinois? That's an easy answer, but maybe it's a little more complicated in practice. The answer is anytime there's a substantial change in circumstances. So what does that mean? Well, and when is that? How long does it take to have a substantial change in circumstances? Unfortunately, it's whatever the judge decides. So the horror story I had was two parents agreed on an allocation judgment, on a parenting plan, marital settlement agreement, super contentious case too. And we got it done by agreement. I don't know how, but we did. And 3 months later, maybe it was even less. Gosh, 2 months. I mean, whatever, 2 or 3 months later. And the mom filed a motion to modify the parenting plan based off of a change in circumstances. And the court agreed that there was a change in circumstances. And it was so frustrating. And I mean, I argued that by a matter of public policy, it doesn't make any sense to allow for the parenting plan to be modified within 2 or 3 months of the settlement agreement being entered, because if any devious client could easily just say, yeah, I'm going to agree to the parenting plan to get what you want, and then as a point of leverage in negotiations, because when you're trying to get to a settlement, you're going to be saying, well, if I give you this, you give me this, and then you can say, well, I'll give you the parenting plan if you give me this. You get that. Then 3 months later, you file a motion to modify. Like, why is that good for public policy? I think that was a huge mistake that when the judge allowed that to happen, if for no other reason than violating the public policy. But I mean, as you say, there's no, as you can see, there's no time allotment here. It doesn't have to be 6 months, 2 years, whatever. Any amount of time is fine, so long as you can show a change in circumstances. Change in circumstances can range from non-payment of child support, the child getting older, which is kind of a time issue there. So people used to think, well, every 2 years you automatically get your support modified. No, you have to motion the court for modification. But if it has been 2 years or a year, just the children getting older, the case law has recognized is a change in circumstances. So you can certainly do that. And the theory is, well, as kids get older, they cost more to rear, and that can be a modification. So the change in circumstances is non-payment support could be one. The increase in income, decrease in income, children getting older, moving to a new home, getting married with another person of a different relationship. All of those could be changes in circumstances. So it really just kind of varies, but just something different is really what it is. So that's kind of worth keeping in mind there. And then that's the same for support, but it's also the same for custody or parenting time or visitation. So it could also be going to a new school, getting a scholarship for a different school, or so on. So a child custody or support order may be modified anytime there's a change in circumstances that's not dependent on time, contrary to popular belief.